While the Secure Act has changed the analysis where trusts are beneficiaries of IRAs, the general principles still hold true that in order to stretch IRA distributions over an eligible designated beneficiary's lifetime, a trust may need to be a conduit trust. Now, if a trust distribution requirements don't expressly permit conduit trust treatment, action might be needed on the trust prior to September 30 of the year following the year of the death of the IRA owner in order to correct that lack of conduit provisions where permitted under applicable law. A recent private letter ruling, PLR 2021-14011, was a situation where a trustee enacted such a fix through a power of appointment, and the IRS okayed this fix and respected the stretch treatment for the IRA under the trust. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode 181, we're going to take a brief look at any post-death fix for an IRA trust to make sure that it qualifies for an extended payout period if such a qualification is possible. We'll look in particular at this private letter ruling, but with also the caveat that, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And if you'd like copies of these slides, please email me at griffin.bridgers@gmail.com. Now on to the presentation. Now, prior to the Secure Act, which is a discussion for another time, generally in any situation where you had an individual beneficiary of a trust and you named that trust as the beneficiary of an IRA, you could, if certain requirements were met, stretch out the distributions from the IRA to the trust and then from the trust to the beneficiary over the beneficiary's lifetime. Now, this was typically based on the life expectancy of the oldest trust beneficiary. But the question is, which trust beneficiaries had to be taken into account in identifying that oldest trust beneficiary? Now, post-Secure Act, a lot of these same rules still hold true, but more with respect to an eligible designated beneficiary. But because of the change, I'm going to refer to this as the IRA payout period in this and subsequent episodes where we talk about IRA distributions. Now, it's important to note that as a general principle, pun intended, there is no principle of an IRA trust unless and until a distribution is made from the IRA to the trust. Now, depending on what happens to that distribution, that's going to determine which beneficiaries you take into account in determining the IRA payout period. Now, if no IRA distributions can accumulate as principal, then you have what's known as a conduit trust. In other words, the minute the IRA distribution hits the trust, it has to be spit out to one or more beneficiaries. And whoever those beneficiaries are, as long as they're individuals, you're going to use that pool of individuals or that one individual to determine the IRA payout period. So whatever that individual's life expectancy is, you'd use that to calculate the IRA payout period. Or if it's a group, you'd find the oldest individual and use that individual's life expectancy, with the caveat that post-Secure Act, that individual must be an eligible designated beneficiary to qualify for that treatment. Now, if you don't have that type of provision in other words, if IRA distributions can accumulate as principal of the trust, then you have to take into account practically every potential successor beneficiary under the sun. And they're all going to count towards the IRA payout period. So if you can identify the oldest individual, then in the worst case, post-Secure Act, you could qualify for a 10-year payout, which has no annual distributions required. It could be a lump sum. Or if you have an eligible designated beneficiary who is the oldest, you could qualify for a lifetime stretch with some caveats as well. And generally, you can disregard remote contingent beneficiaries under a particular Treasury regulation. But what really throws a wrench in the works is if you have a charity or an estate that could benefit from that accumulated principal, in which case that's where you have the worst case scenario that the 5-year payout is going to be required. So most of the time, to avoid this risk of a 5-year payout, to maximize IRA stretching, you need to have a conduit trust, which has its own catches. It's really useless for asset protection purposes just because there's no accumulation in the trust and no protection of assets in that trust that would otherwise be subject to a spendthrift clause or discretionary distributions or anything else that would protect the beneficiary from claims of their creditors or protect the beneficiary's share of the trust from claims of creditors. Now, having looked at that, there's really two testing points for beneficiaries who count towards that payout period. You have to look at who exists at both dates. One, they have to be beneficiaries as of the date of the death of IRA owner, and two, you have to look out to September 30th of the year following the year of the death of the IRA owner, and those beneficiaries still have to be beneficiaries at that point. So you only count the beneficiaries that you have at both of those testing dates. Now this is significant because what you have here is a runway. You have a fixed period where you could go in and, for one, maybe pay off successor beneficiaries to keep them from counting towards that payout period, or two, or you could do this in addition to the payoff too, you could fix the trust maybe through a modification or a decanting, where possible, maybe to eliminate some of those beneficiaries or to change the distribution requirements to create a conduit trust. Now, generally, it's difficult with modification or decanting to eliminate beneficiaries directly, so what you'd be doing is maybe changing this to a conduit trust so that the beneficiaries are still there, but the IRA distributions can't accumulate for their benefit. Now, not all states recognize modification or decanting, but depending on what power or the beneficiary or the trustee has, you might be able to accomplish this through an exercise of a power of appointment. And that's exactly what happened in this private letter ruling. There was a situation where the trustee, after the death of a secondary inherited IRA owner, exercised a power of appointment to create conduit trust provisions within a trust that divided into separate shares through also another separate exercise of a power of appointment, so that there were 2 shares, 2 IRAs for children of a sister who received and these children really received their benefit through the exercise of a power of appointment by the deemed IRA owner in this case. So that was the beneficiary's power of appointment, but the trustee also had a power of appointment that was exercised to fix this issue. And that fix occurred by the testing date of September 30th. In other words, prior to that September 30th deadline, the trustee exercised this corrective power of appointment to add the conduit trust provisions. Now, that being said, the IRS okayed this. You still had to go through the expense of the private letter ruling and everything like that, which may have been required by the IRA custodian. But one thing I want to point out here is that technically what this was a decanting of the trust. But not every state recognizes the actual mechanical remedy of decanting a trust. Now, for those states that don't, really this is based on a common law power of appointment, which recognizes the fact that a trustee's power to distribute assets to trust beneficiaries or for their benefit is technically a power of appointment, which can be exercised to create a new trust with similar or different provisions. Now, usually that would have to be a fully discretionary distribution power in order to have the full teeth of that power to make this correction. So that was likely the case here. And this would really be the remedy in states which do not formally recognize decanting as part of a trustee's authority. Now, that aside, there was a fix here through a power of appointment, aka decanting, but you need to beware the effect of powers of appointment to begin with, because this could have gone the other way. For example, if the trustee or a beneficiary could have exercised a power of appointment in favor of, say, an older individual or an estate or a charity, that would affect the payout period, or even a creditor of the individual or their estate. So, It's important to make sure that the trustees or the beneficiary's distribution power or power of appointment does not include any of those forbidden beneficiaries. Because remember, especially when you have a non-individual, that could create that 5-year payout period for the IRA, which limits the IRA stretch. Now, if you have a beneficiary or a trustee for that matter that has a problematic power of appointment, it may be the opposite, that you're not looking to exercise that power of appointment by September 30th to fix the trust, but instead that you're looking to maybe have it released by September 30th as the fix so that it can't be exercised in favor of any of these problematic beneficiaries, like an estate or a charity, or an older individual. So in that situation, the IRS has, through a private letter ruling, specifically condoned the fact that you can have a partial release just for purposes of getting rid of those more problematic beneficiaries. And as long as that release complies with state law and is done by that September 30th fixed date, then it will be valid. Now, state law is the important part there, where the release may, in a sense, be a disclaimer. So you're really going to have a 9-month period after the IRA owner's date of death to make that release to avoid any sort of gift tax issues or violation of a spendthrift clause. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.